Board, as well as a member of the Special Investigations Committee of the Board. And on my left is Ana Montesantos and David Skeel, also board members and members of the Special Investigations Committee of the Board. Welcome all persons in attendance at this public hearing of the committee, and also everyone who is watching the live stream of the meeting via Board's website. I'm pleased to say that the audio of this meeting via the webcast is available in English and a simultaneous Spanish translation. If you log into the English website, the audio will be in English, and if you log into the Spanish website, you will hear the simultaneous translation. I will now turn to my fellow committee member, David Skeel, to give a brief history of the establishment of this committee, its mandate, and the retention by the committee of Kobre and Kim as independent investigators in charge of the debt investigation. David?
Thank you, Arthur. Last summer, on August 2, 2017, the board announced its intention to conduct a comprehensive investigation of Puerto Rico's debt and its relationship to the fiscal crisis. And to do this, we use the board's authority under PROMESA Section 104, which is 48 U.S.C. Section 2124. On August 6, 2017, the board formed a special committee, which is the committee at the table here, for the purposes of overseeing and appointing an independent investigator to carry out the debt investigation. The members of the committee are, as I said, sitting here today, Arthur Gonzalez, Ana Montesantos, and myself. At its formation, the board designated and delegated to this committee any and all authority to pursue investigations pursuant to the board authority that I just referred to. The board also delegated to the committee the power to determine the scope of any such investigation and to retain any investigators, agents, advisors, consultants, attorneys, or any other professionals as, in the committee's sole discretion, it deems appropriate. Following the issuance of a request for proposal in this committee's meetings with numerous candidates, the board, acting through this committee, retained Kobre and Kim, LLP, as the independent investigator, and we did that on September 1, 2017. The three committee members sitting here today are the only members of the board, the only of the 7 board members who were involved in any way in this process. We were the ones who evaluated the responses to the request for proposals. We were the ones that met with the candidates, and we were the ones who made the decision to retain Kobre and Kim as the independent investigator. We asked Kobre and Kim, as the independent investigator, to conduct an investigation under PROMESA into the factors contributing to Puerto Rico's fiscal crisis, as well as Puerto Rico's debt. Specifically, we asked the investigator to review and to investigate very thoroughly, over the course of almost a year as it turned out, 3 things. First, the factors contributing to Puerto Rico's fiscal crisis, including changes in the economy, expansion of spending commitments and entitlement programs, changes in the federal funding it receives, and reliance on debt to finance a structural deficit. 2, Puerto Rico's debt, how the proceeds of that debt were used, the relationship between the debt and Puerto Rico's structural budget deficit, the range of the types of debt instruments, and how Puerto Rico's debt practices compare to the debt practices of states and large municipal jurisdictions. And finally, third, Puerto Rico's debt issuance, disclosure, and selling practices, including its interpretation of Puerto Rico's constitutional debt limit and other related parts of the Constitution. Throughout the debt investigation, this committee and the board's general counsel consulted with the independent investigator as to the status and the progress of the work on the report.
Thank you, David. I'll just give a quick overview of the agenda for this public hearing. First, we'll start with a presentation by the Kobre and Kim investigative team, which will include a discussion of the report's findings, the process by which the investigation was carried out, and the recommendations in the report. It'll be followed by a question and answer session that will include some of our own questions and questions submitted to today by members of the public, as well as other stakeholders. And that will be followed by a panel discussion of the report to be led by a moderator, which will discuss potential reforms in governmental structures and debt issuance procedures resulting from the report's recommendations, and then we'll have a conclusion. Now I would like to welcome the team from Kobre and Kim, which will review the findings and process. And before your presentation, thank you very much for your good and thorough work. We look forward to hearing your presentation.
Thank you very much, Ms. Matos Santos. Thank you, Judge Gonzalez. Thank you, Professor Skeel. My name is John Curiel. I'm a partner at the firm of Kobre and Kim. I appear here today with my partner, Farrington Yates, and on behalf of the entire team at Kobre and Kim that worked on this critical matter of public importance, I want to thank this committee for its trust and support through the course of our investigation. I want to thank the people of Puerto Rico who participated by providing public comment, public questions throughout the course of our investigation. And I want to thank the members of the press gathered here who are doing an important public service in reporting and increasing awareness about our work, which was work we undertook with great sincerity of purpose and to which we devoted tremendous amount of personal commitment. I think everyone who worked on this project understood it to be an investigation that required the very highest personal degree of commitment. As a former federal prosecutor myself, I will say that I was not the only former federal prosecutor who worked on this report. We took it as a matter of public importance that we bring to bear all of the investigative tools that we learned as prosecutors in doing this work. And we are very, very privileged to present the results of our work here today. As of May 3rd, 2017, Puerto Rico had about $74 billion of bond debt and $49 billion of unfunded pension liabilities. As we say in our report, those are simply catastrophic numbers from the standpoint of this economy. It is a financial catastrophe, but also a humanitarian one. And we never lost sight in the course of our investigation on the ultimate humanitarian burden that Puerto Rico's debt has on the people of Puerto Rico. The largest issuers, as set forth in our analysis, were the COFINA structure, General Obligation or GO debt, and PREPA, the electrical authority here in Puerto Rico. And as our analysis sets forth, both in our executive summary and at length in our report, the story of how Puerto Rico got here is complicated and draws on a number of factors that have to do not just with the market, but political factors, and they are reviewed at length and studied at length in our report. As set forth in our executive summary, when the possession tax credit 10-year phase-out was terminated in 2006, Puerto Rico faced a number of challenges that are well known to the people in this room. They included a declining population, increasing unemployment, mounting budgetary issues, and escalating pension liabilities. And unfortunately, instead of implementing long-term plans to stimulate the Puerto Rico economy, balance the budget, fund the employees' retirement system, or ERS, during the relevant period, the political branches of Puerto Rico and GDB turned to the debt markets for shorter-term fixes. Those fixes included the creation of a sales and use tax, a portion of which was purportedly secured by issuances of COFINA, the entry into swap arrangements to generate cash, which closed, at least as a short-term matter, budget gaps, an increase in deficit finance, and the issuance of Puerto Rico-related bonds that were supposed to be secured by contributions to ERS. Now, some of these structures ultimately resulted in the incurring of billions of dollars of liability, but did not include some of those calculations when reaching decisions about constitutional debt limit issues. And at times, in the absence of certain regulations, which we discuss at Part 11 of our report, underwriters, that is investment banks, sold the Puerto Rico-related bonds through closed-end funds in which only Puerto Rico investors purchased shares. And many of these local closed-end funds were also managed by affiliates of the same investment banks that underwrote the Puerto Rico-related bonds. Another issue we studied was GDB. GDB had a dual role during the period of our analysis. That role, or those roles, included two functions that ultimately became unsustainable when done in tandem. One was to serve as fiscal agent of the Commonwealth, and the other was to serve as a source of liquidity, sometimes in the short term, for many issuers in the Puerto Rico government. And those two roles ultimately, as I said, and as we report at length in our final investigative report, on the basis of dozens of interviews, proved unsustainable. As the Puerto Rico-related entities amassed unsustainable levels of debt, credit rating agencies became increasingly concerned about those entities' perpetual reliance on support from Puerto Rico and GDB, and they ultimately downgraded Puerto Rico's debt to junk status by 2014. And as each of the Puerto Rico entities lost access to the capital markets, the short-term fixes that I've been discussing so far today strained the liquidity of GDB itself and made it untenable for GDB to serve its dual roles. Eventually, many of the Puerto Rico-related entities sought bankruptcy relief in the Title III proceedings, and we are where we are today. In very brief overview, that is the complex of factors that, during the relevant period, led to the chart we see before us today, the $74 billion of bond debt and $49 billion of unfunded pension liabilities.
So as Professor Skeel has indicated in the opening statement, we, Cobre Kim, were hired and retained as the independent investigator to look into certain things, ultimately as mandated by PROMESA, but our review and instructions came from the special committee here with support from the general counsel to the board. The mandate, again, was to review the factors that contributed to Puerto Rico's fiscal crisis, including evaluating the expansion of spending commitments and entitlement programs, changes in federal funding, and reliance on debt to sustain and finance a structural budget deficit. We were also asked to look at Puerto Rico's debt, the general use of proceeds, and the relationship between debt being issued and the structural deficit, the range of different kinds of instruments that were utilized, and how the debt practices of Puerto Rico compared with states and other large municipal jurisdictions. The last point, as far as instruction, was that we looked at Puerto Rico's debt issuances, disclosure, and selling practices, including its interpretation of the constitutional debt limit and how that impacted issuances as they were coming to market. Essentially, the goal was to identify the factors which contributed to the crisis, identify and evaluate potential avenues of value recovery, and ultimately to make recommendations to ensure that the citizens of Puerto Rico don't have to encounter a circumstance like this ever again. And these mandate and the goals are reflected in our independent investigative report.
So to advance those goals, we designed the scope of our investigation to answer the questions that were set out, not just in the statute, but by the committee. And those two overarching questions that Farrington summarized for you were basically, how did this happen? How did the debt crisis come to be? In the service of answering that question, we sought first the voluntary cooperation of people who were involved in making decisions both in the private sector and in the public sector. That we were very gratified to receive. We had over 120 witnesses who agreed to speak with us and to provide information both in the form of documentary evidence and their statements to us. we were able, and we were very gratified by this, to avoid a lot of litigation involving subpoena practice. The dates that we've been kicking around are very significant in the history of Puerto Rico. We were hired on September 1st to undertake what was already a very big job, and then, of course, by September 20th, we were in a very different world. And the notion in September of 2017, October of 2017, of litigating subpoenas in Puerto Rico State Court struck us, and I think it was a very wise decision, would be a waste of Puerto Rico tax dollars and the taxpayers' time and the court's time. And so we focused at that moment on seeing who would talk to us voluntarily, understanding that we were saving the time and resources of the taxpayer by avoiding subpoena litigation. And gratifyingly, witnesses including former senior government officials, underwriters, investment bankers, rating agency professionals, and outside professionals and advisors, including lawyers, were willing to sit down and talk with us. Over 120 of those folks spoke with us. We reviewed over 250,000 documents, including many documents that, because we have about a dozen native Spanish speakers on the team, including myself, we were able to review without translation. Every time a witness wanted to speak with us in Spanish, we did it in Spanish. We did not have translators. We just conducted the interviews in Spanish, took our notes in Spanish. And we cooperated with numerous regulators who had either previously or simultaneously with our work undertaken their own evaluation of these facts. Similarly, because our work was going on at the same time that a Title III process was underway, and mindful of the court's direction in that Title III process, we had weekly conversations with counsel for the committees to make sure that we had clarity about our work and its relevance to their inquiries, and gratified that that cooperation was successful. Those are the investigative tools we use to answer or to gather evidence about how the debt crisis happened. Those same sources of information and evidence inform the second big question in our report, which is what can we do to make sure this never happens again? The recommendations that we set forth in our report, we set forth humbly. We set them forth understanding that the people of Puerto Rico and the democratically elected representatives of those people are ultimately the folks who have to make the determination about what policies make sense. And our goal was to inform those determinations and make our evidence available for their use of the taxpayers, the voters, and the democratically elected representatives of those people.
So over the course of our investigation, we identified those on which we focused our attention based on our mandate as directed by PROMESA and consultation with the Special Investigation Committee. And those are outlined and detailed in various sections of the report, including a discussion of the Government Development Bank, GDB, Puerto Rico's public utilities, COFINA, the Employees Retirement System, Puerto Rico's budgeting, external reporting, and accounting functions, the calculation of the constitutional debt limit, a discussion about the role of credit rating agencies with respect to the issuance of debt, selling practices on island and off island with respect to Puerto Rico-related bonds, the ethics framework that was in place in Puerto Rico to address the issues regarding individuals moving from the private sector to the public sector and back again, the use of interest rate and other swaps as financing mechanisms, Puerto Rico's lack of a mechanism in order to approve and validate debt as it's being issued in the event that there is some question as to its ultimate validity, and also the possession tax credit. Those are each represented in a specific chapter in our report where we go in depth into our findings related to each, and again, for ease of reference, included in the executive summary at the beginning of the report.
So obviously, there's a lot more in the report than you'd probably want us to discuss today. Using the comments and questions we received from the public as our guide to what to focus on in this presentation, we identified a few key areas for discussion today. They are the budgeting and accounting conclusions that we reached, the issues that I discussed a few minutes ago about the dual role of GDB, ERS, PREPA, potential claims available to different stakeholders in the process. And we'll conclude with a Q&A with the committee. They'll be posing questions to us that gather together, if you will, the feedback we received from the public. None of this is to say that the other areas of our report are not worthy of the voters' and taxpayers' attention. They should please read them. We're focusing on these key areas of discussion because we're trying to respond to what the public feedback has been. So let's begin with the first of these areas, which is the budgeting and accounting procedures that we reviewed during the relevant period to our investigation.
Thank you. So we were asked specifically to assess how accounting processes, procedures, financial information, disclosures, et cetera, were handled, if there were any issues that we determined should be disclosed, and any problems that it created, and then finally recommendations from our perspective on how to ensure that proper financial information is collected, used, and disclosed to the public when necessary. So the first finding was that Puerto Rico failed to develop budgets based on accurate growth and revenue estimates to which it could not adhere. The underlying point being is that with information coming in that you really can't get a handle on, it then affects the entire process as far as evaluating next steps and planning, budgeting, et cetera. We also found that Puerto Rico did not sufficiently curtail spending. Very straightforward point. It spent more than revenues coming in, and that, of course, is addressed with respect to the budget deficit and deficit financing, which we'll talk about in more detail later. As far as financial reports, in many times we found that Puerto Rico's external financial reports were stale. They were relying on dated information where it was overcome by new information that would have provided more accurate insight into next steps, budgeting, et cetera. We also found that Puerto Rico failed to develop the infrastructure and resources it needed to support efficient accounting functions. There are a number of different systems being used in different places. They didn't talk to each other, and as a result, the ability to gather complete information was challenged. We also found that Puerto Rico did not optimize the use of its independent auditors when compared to other issuing municipalities, et cetera. So ultimately, what was the impact of these findings and ultimately failures? First and foremost, there were substantial deficits resulting from budgets relying on erroneous assumptions on economic growth and unreasonable revenue projections. The belated release of external financials interfered with the ability of interested parties to acquire sufficient transparency into matters that concerned or were otherwise intertwined with Puerto Rico's fiscal health. And ultimately, with a failure like that, there was a loss of investor confidence. So, what did our report recommend in light of these findings? And I'll just put them out because there are a number of them, so that you have a chance to review them as I go through them and before I get to each one. The first one is really very straightforward and pretty basic. Adopt a more rigorous budgeting process. Second is to continue to transition to GAAP-compliant budgeting. Third, study the viability of creating a dedicated and centralized board that is devoted to aggregating critical data and preparing and releasing consolidated external reports. Adopt a modernized accounting and budgeting system. Create a board to expedite preparation of external reports. Reshape the responsibilities of the Department of Treasury, including requiring that OMB and the Planning Board report to it. And, notwithstanding all of the guidelines, et cetera, that we have suggested, adopt a mechanism to sanction entities which fail to comply with accounting, budgeting system that's implemented. We also found that it would be helpful to limit the turnover of accounting employees and prohibit the turnover of auditors without cause. Ultimately, to centralize and streamline the budgeting, accounting, and financial reporting functions and provide online public access to spending data and adopt a formal deadline for publishing externally financial reports. So, with respect to keeping track of numbers, finances, budgeting, et cetera, we've found a number of issues that were raised, and our recommendations, as just described, were meant to address those going forward.
Thanks, Farrington. The next topic that we'll address today is the important and dual role of GDB in the debt crisis. Our key findings, which I'll put out first so that we can review them together, are as follows. The GDB, populated as it was by financial professionals, had a reputation as a prestigious financial institution in the island, and it acted in that capacity as both the fiscal agent and lender for Puerto Rico-related entities. The various administrations' policy goals affected decision-making at GDB in both of those capacities. We found that there were political considerations both in fiscal agency advice that GDB was giving about the timing of bond offerings and also in GDB's lending practices. And our report sets these out in great detail. But in summary, as a lender, GDB provided interim financing to the Puerto Rico-related entities in advance of their bond issuances. So as an example, if PREPA was going to market but had an immediate need for access to money, GDB would fill the gap. It would provide liquidity pending repayment after a bond offering. They also, at GDB, provided longer-term financing to the same entities. And I think, as the report demonstrates, they did so without applying and enforcing the strict credit and repayment standards that private lenders would have demanded of the Puerto Rico-related entities. And as a lender, then, GDB both facilitated easier money than the private sector might have facilitated, and allowed a gap closing with different standards than private lenders would have applied in lending out bridge financing. In its capacity as a fiscal agent, GDB allowed the issuers to issue more debt instead of requiring fiscally responsible alternatives like rate increases. GDB also supervised and approved all bond issuances, including the selection of underwriters and advisors. And a conclusion of our work is that GDB did not monitor the public utility's actual use of bond proceeds in relation to the represented uses identified in offering documents. In plain English, what that means is when PREPA or PRASA went to market and talked about what it was going to use the money for, there wasn't a function at GDB, generally speaking, to make sure the money was actually spent on those things. And I think our recommendations start from the conclusion that that has a clear impact. If nobody is making sure the money is spent on what it's raised for, there's a loss of investor confidence, there's a loss of public confidence, and there's a loss of accountability. At times, GDB approved loans when there was not a known source of repayment for those loans. The issuers repeatedly engaged in what folks in the industry called scooping and tossing, which is essentially paying your phone bill with your credit card, not paying debts as they come due, but kicking off to the next period, the next payment by using borrowed money to pay for current expenses. The Puerto Rico-related entities became dependent on bond proceeds and GDB for liquidity, again, instead of raising rates as might be required. And ultimately, by 2013, the Puerto Rico-related entities' dependence on GDB and Puerto Rico became a threat to GDB's own liquidity. That is, the bank ran out of money. And by 2014, restructuring became the only option for GDB. So what are our recommendations in light of these findings? We respectfully and humbly suggest that Puerto Rico's political branches, the democratically elected people who answer to Puerto Rico's taxpayers and voters, should evaluate measures to separate these two functions, to make it so that the fiscal agent for the government, for the people of Puerto Rico, and the lending function that GDB's historically occupied be segregated for GDB's successor. Specifically, Puerto Rico's political branches should consider the following reforms laid out in our report. In terms of fiscal agency, we think it's worth considering staggering the terms of the board members who serve on the fiscal agent to make sure that gubernatorial administration changes do not immediately or abruptly result in a change in continuity of policy. We would request that or recommend that there be a consideration of whether to condition disbursements from the Department of the Treasury upon the fiscal agent's review and approval of the soundness of those disbursements. We would recommend that the fiscal agent act more as an impartial conduit of information to its clients and to the investing public, and to be answerable to those clients. We would suggest improved oversight of the Puerto Rico-related entities, as that term is defined in our report. And we would create a separate, or we recommend the creation or the studying of a separate department or division specifically tasked with overseeing on a global level all of the Puerto Rico-related entities and monitoring and auditing their finances in a coordinated, government-wide fashion. And then on the lending side, the same staggered term idea we think would provide some insulation against the risk of abrupt, sudden political policy change. We would recommend the adoption of policies and procedures for a quarterly reevaluation of the collectability of risk, the collectability of debt, on a regular and government-wide basis, not an ad hoc basis. In other words, we're not just, it would behoove the lender to have a coordinated approach to this rather than evaluating the questions only when someone comes to them for money. We would consider or recommend the consideration of the role of any statutory repayment guarantee, but that should not be the sole or controlling factor to inform any collectability analysis. And we would recommend that policies be studied to more closely align credit policy with the framework that a private institution, a private lender would apply to evaluating risk before entering into an additional extension of credit.
So the next area that we were asked to look into, as reflected in our report, is ERS and the funding of ERS. And I think at the time of the Title III filings, there was about $49 billion of underfunded pension obligations, liabilities. And so that is a staggering number. And so we were asked to evaluate how that happened, and specifically focusing on the circumstances and allegations around the issuance of ERS bonds. What did we find? We found that ERS struggled perennially, continually, with unfunded liabilities, and by June 20th of 2005, had actuarial liabilities of in excess of $12 billion, of which only 19% were funded. The proposal to issue bonds that were secured by the stream of employer contributions included a recommendation that ERS issue at least $7 billion in new bonds to make near-term payments and invest the remainder in an arbitrage strategy, essentially to take some of the money to meet immediate demands for payment of benefits, et cetera, and then take the rest of the money and invest it so that the return ultimately would exceed the amount that was funded, so there would be a profit that would go to the benefit of the beneficiaries of ERS. So in the first half of 2008, ERS issued about $3 billion of bonds, but it was issued exclusively into the local market. No bonds were made available to off-island purchasers. The evidence indicates that additional ERS bonds were not issued the second half of 2008. Why? Because the market had turned, so there was a change in the market that was completely unanticipated. And then in 2009, there was a political decision that the additional ERS bonds should not be issued. So what was the impact of these decisions and findings? Well, without the additional $3 million that was slated to be issued as the second tranche, the arbitrage strategy had little chance of succeeding. Why? There just wasn't enough money to put to work to make it a success and to generate the profits that were originally anticipated. Along those lines, an arbitrage strategy might have worked, but for the changes in the market and the fact that only $3 billion out of the 7 were deployed. By 2017, of course, the system then was changed to a pay-as-you-go by decisions from government. So what does that mean now? Among other things, there is a prohibition against ERS issuing bonds that was done by the legislature in 2011. And the validity of bonds, et cetera, is now subject of litigation in and around the Title III case. And so whether in fact these bonds are valid and if they were issued, secured by proceeds, contributions from employers, is still subject of litigation in courts and will ultimately be decided by them.
So next we'll discuss PREPA, one of the most significant issuers of Puerto Rico debt historically, and our findings with respect to PREPA. We interviewed a number of current and former officials at PREPA. We're able to review a great many of the transaction documents and communications related to those transaction documents, and to undertake a thorough review, at least during the relevant period, of how decisions were made at PREPA. And our key findings include the fact that in addition to appointing the majority of PREPA's board members, the governor appointed many layers down of empleados de confianza, the term for political appointees, not only to high-level positions, but way down into the weeds at PREPA, to many operational and technical positions that one might not traditionally think of as having a political relevance at all. This had an impact because when there was a change of administration, the result was that all the way down into the operational and technical corners of PREPA, there was a loss of institutional knowledge. Folks who were political appointees were replaced, and you'd have people who simply had not been part of the decision-making process in the preceding administration. So they didn't have the benefit at an operational and technical level of what had been done in the immediate past. In this way, politics directly impacted PREPA's functioning. Politics also impacted PREPA's rate structure. That is, because of the mix of fuel that PREPA uses to provide electricity in Puerto Rico, rates are high, but yet insufficient to cover operational expenses and capital improvement projects, and at the mercy of fluctuations in the global price for oil. PREPA systematically included uncollected revenues when it calculated and represented to the public its ability to cover operations and debt service, which is something the trust agreement required it to do. And neither GDB nor the underwriters who were buying and then selling PREPA's debt monitored PREPA's actual use of bond proceeds as compared to what they told the public they would use their proceeds for. And what was the impact of these conclusions or findings of fact? First, the sheer number of empleados de confianza inside PREPA predisposed PREPA to huge turnover, loss of institutional knowledge, and decision-making that was simply unresponsive to market forces. Second, to compensate for a suppressed base rate, PREPA became dependent on short-term liquidity from GDB, and the principal means of repaying those loans from GDB was just issuing more debt, rather than, for example, raising the other factors of the rate in addition to the base rate. PREPA was able to issue more debt despite not having the ability to cover its operations and debt service as required by its trust agreement. Finally, we conducted, with the assistance of professionals at Duff & Phelps, a deep dive into the 5-year period between June 30th, 2010 and June 30th, 2015, and found that the amount of bond proceeds earmarked for the construction fund exceeded the value of utility plant additions after adjustments, and the net change in the reported value of PREPA's restricted cash by approximately $430 million. Our report goes through in detail the implications of this finding. We chose this period for a deep dive because of PREPA's relative size as an issuer. It was an important issuer during this time period. And we wanted to provide some detail and context and focus on the gap between what was raised and what we found in our report. So, what are our recommendations as to PREPA? To the extent, and indeed even if it is privatized, there are some practices that we would, not sure what just happened. There we go. Let's see if I can fast forward. At this point, you should all be happy that not all 608 pages of our report. All right. So at the top level, we think that the boards of directors of the public utilities, to the extent that they are answerable to the administration, should be, again, recomposed to either stagger or ensure that the terms provide for some degree of continuity. This goes all the way down to the operational and technical level, and we think that from the top to the bottom there should be some degree of making sure that there isn't a loss of institutional knowledge. We would also propose an establishment of a committee to audit the public utilities. We would require or recommend that the public utilities be required to disclose their actual use of bond proceeds. That is, tell us not just what you plan to use the money for, but then show us what you used it for. We would recommend the establishment of an independent board for each public utility responsible for determining rates, obviously a matter of deep public importance because it affects everybody's pocketbook at the end of every month. We would empower an independent fiscal agent, going back to the other part of our presentation about GDB or its successor, to implement the public utilities financial oversight agreements to comply with rate covenants. The financial oversight agreements were intended and played some role in advancing the goals we've talked about, but an imperfect and incomplete goal we found during the relevant period. We would propose the elimination of contributions in lieu of taxes, as set forth in our report.
So the last section of our report was an extensive discussion of potential claims that could be brought by different claimants. And so we included a lengthy discussion of various actions and claims that could be brought under federal, Puerto Rico, and state law. And we followed the facts. Why? Because who brings claims depends on really who is looking at the situation. And so an investor might have a claim that a regulator might not want to pursue. A purchaser of a bond may want to pursue questions about disclosure when they bought the bonds. That may not be a claim that another entity would bring. And so what we did was we followed the facts and put down in our report facts that led to certain potential claims that we identified. Were they every claim that's possible? Clearly, no. Why is that? Because, again, who wants to bring a claim will certainly then evaluate what kind of claim they can bring and under what circumstances. What is the one thing that's common to whoever's asking that question? It's the facts. And so our report puts down the facts, how people review the facts, evaluate the facts, and apply the facts, particularly when assessing what kind of claims to bring, is really up to them. From the independent investigator's perspective, we wanted to put down what we thought were facts that raised questions, suggested issues, and ultimately would be ways and paths for the people of Puerto Rico and others to evaluate if, in fact, there are potential claims that can be brought against those that were involved in the situation. So the first group of claims that we evaluated were ones that were those that could be asserted essentially under securities laws, federal, Puerto Rico, perhaps state, essentially around issues like actions taken during the issuance of bonds, what sort of disclosures were made, what sort of emissions were reflected, what did they not disclose, etc. And so you have situations where regulators, the SEC or others, may take action to police and prohibit conduct in the future. And then on the flip side, you have potential claims from people that bought the bonds and the debt that was being issued. And they can also look at those facts to see if an omission was material and if they would have bought that bond if they had known that fact, and was it required that that fact be disclosed. Those are the kinds of claims under securities laws that we evaluated and put down in our report. There are also, of course, claims that can be brought under Puerto Rico law, state law, federal law, again, with respect to fraud, with respect to breach of fiduciary duty, with respect to actions taken by decision makers when issuing or allowing and authorizing the issuance of bonds or the incurrence of debt, etc. And so again, those kinds of what we call common law claims really cover a wide range of issues, including misrepresentation, unjust enrichment. That's a fancy legal way of saying somebody got money or something that they're not entitled to, and it should be returned. And so each state, like New York and Puerto Rico specifically, have different rules and regimes for these kinds of claim. So we set those out in our report and then identified circumstances where we thought they might apply. Finally, there are a group of claims that arise by virtue of the Title III filing, which are related to insolvency kinds of claims, claims where debtors take actions against third parties. And so at times it could be to recover transfers or to take action with respect to claims that are being filed in the case because of conduct that occurred that is considered inequitable. These kinds of claims are also described in our report. We, however, did not evaluate those claims specifically. Why? First of all, it wasn't really in our mandate. Secondly, a number of these claims require a solvency analysis. In other words, was a particular debtor, like GDB, insolvent or close to being insolvent before it made a certain transfer or entered into a transaction? And so without the benefit of that kind of analysis, which can be extensive and very costly, we left those kinds of claims for others to evaluate and ultimately, if deemed necessary, to pursue. So in our report, you'll find a summary of the claims that we identified. You'll find a more detailed analysis of the facts that we uncovered that suggest potential claims with respect to various actors and in various circumstances. And ultimately, as part of our charge, to find ways which various claimants, not just the debtor, but investors, the people of Puerto Rico, can perhaps pursue paths to recovery to fill in the loss that they've experienced.
Thank you. Thank you, John and Farrington, for your presentation. My colleagues and I have a few questions for you about the investigation and the report. We also have been reviewing questions posed in the media as well as those that were solicited and received from members of the public in advance of this hearing. Some of those questions submitted were directed to us, the Special Investigation Committee, and others were directed to you. Of those questions being asked of the independent investigator, you already addressed some of them during your presentation. Well, we don't have time to ask you all of the remaining questions here today. We've selected a few and are interested in your feedback on those questions. And I'll begin with this question. We have received questions from many people about why your report did or did not include, and the level of attention given to, certain topics or specific issuances. Although you touched upon this in your presentation, can you please describe the process of determining the scope of your investigation?
So I'll take that one. Certainly. So I think the first and most important goal we had was to be responsive to the mandate of the statute and to the mandate of the committee by conducting an investigation that would, first of all, be done in time to provide real-time findings and recommendations. We could have started our analysis decades ago. We could have analyzed bond offerings into the 60s and 70s. We could have spent years, frankly, trying to unscramble how Puerto Rico got here. Our focus, however, was on providing recommendations and findings in time for Puerto Rico to use them. And so with that as our goal, Judge, and in consultation with the committee, we focused on the period roughly beginning in the year 2000, and then we focused on the largest issuers of debt, and reasoned from our findings in that period to the conclusions that we've set before you today. And the scoping of our work was undertaken with that as our focus. And then during the course of our work, we issued interim reports about how we were progressing and what the direction of our work was, and kept the committee up to date and the public up to date about what we were focused on with that as our goal. So to the extent that folks are wondering why we chose the issuances that we chose to study, that, in summary, is the basis upon which we selected them.
John or Farrington, I wanted to take a stab at summing up what I think I heard in your findings and see if it rings true or anything you might add. I mean, what I read was Puerto Rico, and what I listened to today is Puerto Rico had a fundamental economic problem that led to a substantial revenue decline, definitely in the examination period, and as you just spoke to, in some ways, lingering for decades. It was in part based on the triple tax exemption of its bonds, flexible interpretation of its balanced budget requirement, and a limited application of its debt limit. Puerto Rico had access to capital and used it to maintain services and delayed the day of reckoning. Similarly, it depleted its pension funds and used those to pay pensioners and to maintain services without paying what was needed to honor the commitments it made to its retirees. Bottom line, Puerto Rico faced massive problems and decided not to confront those head-on. This was done by government, elected and unelected. It was done with knowledge of a broad set of stakeholders, including business leaders, civic leaders, labor, and others. And it was enabled by financial institutions, rating agencies, the retail markets, and most recently by hedge funds. The report finds many practices that were troubling, problematic, very much not in line with best practices across the nation. It did not find any substantial misappropriation of funds. It did find instances where bond proceeds were not used for the purpose for which they were issued. It identified numerous examples of bonds used to fund operating costs or to push out debt payments instead of for long-term infrastructure. And it also identifies many issues that could lead to valid claims that will have to be further examined. Is that a reasonable summation?
I think that's a very fair takeaway from the report. And the points that you raised specifically are reflected in the executive summary of the report. And then, of course, the detail around each one of those points is found within the report itself. But each one of these points that you talk about, including putting off the day of reckoning, deficit financing, going to the bond markets, the debt markets in order to bring in money to meet immediate needs as opposed to long-term solutions, and the various actors that knew about what was going on and participated in what was going on, that all is very clearly set out in our report. And the specific details that would actually address each one of the points that you made and support those points are very clearly in our report.
Thank you.
I have a more focused question that was submitted through the Oversight Board website and the committee's website, and that is, should a reasonable due diligence process have at least identified the possibility of a restructuring or reprofiling or something of that sort prior to the disclosure of this in 2014? And if so, if it should have been identified before 2014, when should the possibility of restructuring or reprofiling first have been disclosed?
Sure. So I'll take this one. What we did in the report is we put out the facts as we found them, as we asked questions about disclosures, particularly in and around the 2014 Go Bond offering. Whether a process is reasonable or not, or whether it should have been disclosed sooner, that's really not for us to answer. The facts are out there. Others can evaluate those facts and then determine if they have their own claims to resolve.
Thank you, Farrington. I have another question for whichever one of you wants to answer, but I understand you didn't reach a conclusion on the legality of COFINA and its treatment under the debt limit. Can you speak a bit more to that and kind of why not?
Sure. So COFINA and the dispute regarding the priority of COFINA versus GO bonds, whether bonds were issued in violation of the constitutional debt limit and therefore invalid, is all subject of litigation. And so we were not in a position to offer an opinion on something that ultimately will be determined by a court. And so what we did do is that, of course, we focused on the facts around these circumstances as we discovered them. And then we also made recommendations not to the penultimate issue, but around the issues like should COFINA or some other SUT financing structure, the debt issued there, be counted towards the total debt limit of what Puerto Rico can sustain. We thought that that was a good idea and one of our recommendations. So to the precise question, no, we didn't answer. It was purposeful. But what we did was we focused on the facts around the discussion.
Yeah.
Kind of the lessons going forward as well, so that was helpful.
That's right.
That's
And
correct.
I would also direct people who are interested in this question, I would also direct them to the chapter of our work on the historical availability of a debt validation statute, which is a tool that's available in other jurisdictions. And it addresses, I think, on a going forward basis, Ms. Montesantos, your question on what the democratically elected representatives of the people of Puerto Rico might consider as a tool for avoiding this type of question in the future.
Thank you.
I have a closely related question, and you started to touch on it, I think, and that is, there's been a lot of discussion about the 2014 GO debt offering, and among other things, people have alleged that that violated Puerto Rico's constitutional debt limit. Can you speak to what the report has to say about that?
Sure. So again, whether the issuance of the debt violated the constitutional limit is one that ultimately will be decided by a court somewhere. So again, we didn't offer our opinion on that issue specifically. But what we did talk about were circumstances where debt being issued arguably should have been, or our recommendation is that it should be applied to the calculation of the debt limit. As an example, there were certain swaps that were entered into, termination fees, which could have arisen, were material compared to the revenue that was being generated by the issuer at the time that simply wasn't being picked up in any sort of calculation. And ultimately, there are other circumstances where we found that perhaps a review of what goes towards the debt limit and what components are actually calculated would be helpful in ensuring that the budget and the amount of debt that could be issued by Puerto Rico would actually be sustainable.
Thank you, Farrington. Your report includes an analysis of the statute of limitations defense. What are your views on whether that is a viable defense regarding many of the claims?
This is a question I know that's been asked repeatedly, particularly in questions that are going to the board's website. And we wanted to be clear that what we did as the investigator was we evaluated kind of broadly what the typical limitations defenses would look like and would they apply in this circumstance. Now, are those the only defenses that can be raised? No. There are arguments that can be made, again, depending from a person's vantage point, of where a particular limitation might be extended for even a significant period of time. And so what we did was we tried to focus on the ones that we thought were most applicable, that's not exclusive of any other arguments that might be made. And when we did that, we found that with respect to securities violations, there were differences between when the government can act versus when individuals can bring claims, depending also when they're discovered. Puerto Rico, New York, and others have particular deadlines by which claims have to be brought under their regimes. And so we evaluated those when looking at the causes of action that we described generally in the report. And in some circumstances, limitations was going to be a challenging defense to overcome. Does that mean it stops the discussion? No. Again, it depends on arguments that can be made. Some may be more meritorious than others. But from our perspective, when we focused on the most likely argument around limitations and defenses raised there, we thought and covered those that we thought would be most applicable, and did in fact find, Judge Gonzalez, that a number of defenses with respect to certain claims would be challenging to overcome.
Thank you, Farrington. John explained at the beginning of the presentation why y'all pursued voluntary evidence collection rather than compelling people to come. And you talked about the devastation of the hurricane and not wanting to impose another layer of costs on Puerto Rico. Could you say something about why the report is anonymous, why the people that you refer to and quote in the report are not named, but they're anonymous?
Absolutely, that's a very good question. For me, it's ultimately an issue of relevance. If the nature of our charge had been to identify human beings that needed to be held to public account, we would have obviously proceeded in a way that identified them. But that wasn't our mandate. Our mandate was to gather information that would be relevant to the people and to policymakers about understanding what went wrong and understanding how it could be avoided in the future. And the identity of many individuals we interviewed was not relevant to those questions. We spoke to 4 former governors of Puerto Rico. We spoke to dozens of investment bankers, current and former. We spoke to lawyers who advised those investment bankers in buying and selling Puerto Rico's debt, lawyers who advised the government of Puerto Rico. We spoke to elected officials. We spoke to regulators. And the report that is available for the public to review focuses on the consensus or the aggregate of what emerged from that analysis, very little of which has to do with finger pointing, very little of which has to do with the naming of names. And that is because, again, our focus was on being constructive and achieving the goals for which we were sent, and not to engage in a finger-pointing exercise.
Thank you.
Thank you. This is another question that was submitted through the website, or a version of it. Can you talk a bit more about some of the changes that you propose for the use of bonds or the bond issuance process? That you've talked a little bit about them, validation and others, and kind of why not require a referendum every time the Commonwealth, a public corporation, or a municipality is going to issue bonds or take out a significant loan?
Yeah, sure. So our report does make a recommendation for something, I guess, less than a referendum, which is the validation process. And that's a way where a judge can evaluate any questions regarding the validity or the issuance of a particular bond. In some states, I understand, like California, they have referendums when there's material and substantial funding requests and bonds that are going to be issued. And that may or may not be appropriate here. Certainly, it's another tool to be considered. But our focus was on things that could be implemented that have worked in other municipal settings, that didn't require the vote of the entire population, but that could be done in a way that was efficient and relatively quick, and that's what we focused on, the validation procedure.
Thank you.
Thank you, Farrington. I have a question that came from the Twitter feed, and that is, it's been a lot of different question. We know that you reviewed thousands of documents, and you commented on taking a number of the interviews in Spanish,
Yes.
where the person you were interviewing was Spanish speaking. Could you say a little bit more about that, about how many people on your team speak Spanish and the role that played in the investigation?
Certainly. Pues mi español lo aprendí en casa. And there are about a dozen people on our team for whom that was true. I think that's probably one of the reasons why we were selected to do this work, is that from top to bottom, the entire process involved folks who were not just fluent in Spanish, but had native fluency in Spanish, and therefore didn't need emails or letters translated for them, and could conduct conversations in a very frank tone with our witnesses in Spanish. And so there was, I think that was both in terms of economics important, because it saved a lot on translation, but also important from the standpoint of moving things along quickly, and also, frankly, in terms of getting the honest input of witnesses who I think would have reacted very differently to an interview in a language that wasn't their native language. I would say that about, I don't know, maybe it was less than a quarter of the interviews we did, maybe about 20% of the interviews we did, we had witnesses who said, no, I'd rather just do this in Spanish, and then we did. And for others, eran bilingües, una entrevista totalmente bilingüe, y por unas cosas hablamos en inglés y otras en español. And so it was in some cases a Spanglish interview, but I'm very comfortable in Spanglish.
A question that we received a number of times from the media: how much did the investigation and report cost?
Sure. So currently, it's about $16 million. And that's a large number, to be sure. However, to put some context into that number, we wanted to compare it to other, essentially, examinations that have happened in large financial institution or municipality distress situations. And so what we compare that to, just to provide some context, the examination report in Enron was prepared for about $100 million US in attorney's fees. One of the more recent ones produced by the examiner in ResCap was for a total of $90 million US dollars. But that was evenly split between the lawyers for about $45 million and financial advisors and others on the accounting side for $45 million, again for a total of US $90 million. So when compared to other situations in distress, and particularly in light of the amount of debt, et cetera, that was subject of investigation here, the $16 million that we've spent is much less than what was spent in other cases, which arguably were much smaller.
Thank you.
Thank you. Other than the 3 members of the Special Investigation Committee sitting here today, did you permit anyone else outside of your team to review the report prior to publication?
No, the short answer to that question is no. One of the things we did was we made sure that witnesses had an opportunity to confirm that we had accurately attributed statements to them. And so on a witness-by-witness basis, where appropriate or needed, we sort of showed the witness the statement that was going to be attributed to them to determine whether we had accurately quoted the witness. But our conclusions and our thinking were independent. That's why we were hired. And it was quite important to us that we retain that independence by sharing our findings only with the public and you when we were ready to do so, and with no one else.
Thank you.
So I have a question that came, 2 related questions. One came from the media and has been discussed a lot in the media, and the other came from questions submitted to us on our website, and that is, why in the report did you not analyze conflicts of interest and retention questions with respect to underwriters and professionals? Why didn't you focus on that? And then the related question is, we were asked on our website, or one of the questions asked on the website was, why is there almost no discussion about problems at the GDB between 2009 and 2012?
You want to divide that up?
Yeah. Go ahead.
We did.
Yeah.
Is the first answer.
That's right. So with respect to ethics violations, et cetera, we did include a lengthy discussion of that in our report, specifically talking about the ethics regime that was in place, how it was implemented, how it was policed, and how individuals that were impacted were seeking authorizations, waivers, opinions from that particular office as they, moved from one position in the private to the public sector and then back again. And so under the regime that was in place at the time, we didn't find obvious violations other than there were times when certain parts of the regime, like GDB having its own ethics committee, did not seem to be implemented. And that was one of our recommendations, was that it would be implemented and enforced going forward, as well as having a mechanism where any sort of ethics violations can be policed and sanctions and other sorts of repercussions, asserted against an individual that violates. The other issue is that self-reporting has limitations, and so really having a group that understands precisely what the rules are and who's moving around and what is the impact of that was also one of our recommendations.
And to that, I would just add, there are at least 2 chapters in the report that speak to these issues. The first is on the bond offering process. And the second that comes immediately to mind is the chapter on the way the Government Ethics Office functioned. On the first part of the story, we spoke to individuals who, at different points in their career, were either underwriters or working for underwriters, and at others were working at GDB or as counsel to GDB. And we address, I think in great detail, the facts that led to that being true. That Puerto Rico is an island, and that means that there is a relatively small group of folks with the right human capital to play both of those roles. And it isn't, on balance, a wholly negative thing that people have both sets of expertise. However, as we say when we address the Office of Government Ethics for Puerto Rico, which is manned by professionals who are dedicated workers and who have important public functions, there are tools that could make this process more robust, like a whistleblower program, like something that more proactively allows individuals who have ethics questions to raise and consider those questions rather than simply by seeking waivers at the termination of their government service. So to the first part, I think that's what I would say. And then to your question about the period between 2009 and 2012, that was a period that is relevant to our work and that we studied extensively. I think I would say there are 2 families of findings about that period that I would emphasize. The first is the growing use of COFINA as a means of satisfying the sort of capital needs on a short-term basis of the government. And we at length talk about how COFINA's use during that time period vastly exceeded its original proposed use. And the second thing we studied in that time period, specifically in Part 13 of our report, is the termination of interest rate swaps. So during that time period, up to about the end of 2014, the issuers had paid over $1 billion in termination fees to banks that had acted as counterparties to those swap agreements. And the evidence we reviewed, I think, established that the majority of those agreements were terminated for 2 reasons. One, because the credit ratings for Puerto Rico triggered the termination of those agreements. And second, in order to refund and reissue earlier bonds at a new rate, GDB worked with outside swap advisors to achieve that goal. So I think the period between 2009 and 2012 is actually quite central to our report.
Thank you very much for all your considerable work as well as for your answers to our questions. I'm sure we could be here for many more hours. I'm exercising some restraint in not asking you about your findings relative to bond trustees and PREPA and a variety of other issues. But thank you for your report, and thank you to the work of your team. It provides a solid foundation for the work that is to come, which includes sorting through potential claims and deciding which to pursue, and resolving the debt and fiscal issues before the board, and as well as tough questions to wrestle with for the people of Puerto Rico and for the government relating to changes that can be made to prevent the situation that Puerto Rico faces today from repeating itself in the future. So thanks again very much for your work.
Thank you.
Thank you.
Thank you, Hannah. Now I'd like to welcome our panel, which, as we said earlier, will be divided in two segments. The first will be a discussion of the actions that the government of Puerto Rico may decide to take to reform itself in light of the report's recommendations, followed by a discussion of the debt-specific issues. I'd like to thank and introduce our panelists and moderator. The moderator is Kenneth Rivera, President of Puerto Rico's Chamber of Commerce. Our panelists are Alvin Velasquez, Associate Counsel of the Service Employees International Union and former Executive Coordinator of Debt Audit Commission. Francesco Montalvo Vial, member of the Private Sector Coalition. John Mudd, attorney and commentator. Ramon Ponte, CPA and former president of Puerto Rico's Certified Public Accounting Society. All right, thank you all for being here, and I'll turn it over to the moderator.
Thank you, sir. Basically, we would like to present the conversation, the panel as a conversation among the group. So I will be presenting certain general points. I will make certain comments, and then I will let the group of the panel make the appropriate comments as they see fit. The first comments have to do with the original reaction to a brief original reaction to the report. What you guys understood was the original reaction when we received the report, and we saw what was the product of the investigation. At least on my part, I understood that there was going to be more conclusive in certain areas regarding responsibility and things like that. So can I get your brief comments regarding that?
Sure, I'll get it started. First of all, a qualification: I'm the immediate past president of the Colegio de Contadores Públicos, no longer the president, so the views expressed here are entirely my own. Yeah, I guess the first question is always the question of scope, and I think it was addressed on the Q&A, that there's certainly always limits as to how much you can do in a certain period of time and with a certain amount of resources. I think those questions were addressed in the Q&A session as to why the scope of the report was what it was and what's pending going forward. The second, I kind of see the report in two levels. One is how do we not get ourselves into this same predicament again? What measures need to be taken from the administration and budgetary perspective, which is really where the problem starts. And the second is there any responsibility for the past actions that needs to be addressed by the board? I think the first one to me is really the most important. If we don't fix the underlying issues, we'll be right here all over again pretty soon. I think one of the things that were mentioned in the Q&A, the government found additional sources of revenue in 2006 with the IVU, the sales tax, in 2011 with Act 154. but they were used not to address the structural deficit, but just to keep spending. And COFINA became, rather than a source of revenue, a source of pushing, kicking the can down the road, as was commented. So I think we need to look at the report on both those perspectives, and I think to me the more critical is really addressing the administration, budgetary, and accounting issues that were set forth in the report.
Okay, well, good morning. My name is Francisco Montalvo Fiol. I'm the coordinator for the Private Sector Coalition, and I come on behalf of the Private Sector Coalition. And given the fact that we're over 20 different, I represent over 20 different organizations, which basically promote the economic, social, and competitive development of Puerto Rico, and we represent over 400,000 jobs in the private sector in Puerto Rico. So my focus will be more of our interest in the strategies and mechanisms needed to create and boost economic growth, and obviously not really repeat this situation. So that's probably my most immediate critique. We expected a little more specific recommendations for future actions, but I will be presenting a number of our ideas in this respect. But it's a very difficult. I understand it is a very broad report given the situation and obviously difficulties that were faced by the organization. So thank you.
Morning. Name is John Mudd. A few comments. I think the report doesn't address the real roots of the problem. The real roots of the problem are historical and cultural. You can call it socialism, you can call it statism, or whatever you want to call it, but putting the government in charge of all aspects of society is why we are in the mess we are right now. We need to get rid of everything in the government that has no place there. For example, Prepa, Praza, WPR, which is the TV station. We need to reduce government agencies. We need to do all that, and I don't see any recommendation of it. We need a constitutional convention. Why? We got to make clear about balanced budgets. In 1974, the governor of Puerto Rico decided he got an opinion from the Secretary of Justice, more on that later, and he said, oh, you can borrow to balance the budget. Slippery slope down, and here we are. Mm-hmm. We need to make clear, and I think the report does mention it, what is the actual debt limit. That's Article 6, Section 2 of the Constitution. We need also to clarify Article 6, Section 8, which says, first thing you do, you pay debt, public debt. Public debt is defined as bonds. But in 2015, and actually 2016, the government decided not to do it. We need to deal with that. I agree that we need to vote for any issue of any bonds of over, let's say, $400 million that can be discussed. Why? The committee says, oh, the validation process. Well, the validation process has a problem. You need a case of controversy. You need standing. And I've been a lawyer for 36 years in the government in Puerto Rico, and I can assure you, you try that the way the law is right now, it's not going to go anywhere. Standing is not given by a law alone. You need standing from the constitutional point of view. Also, very important, I think we need to think about electing the Attorney General. Why do I say that? Two things. Up until 2015, GDB law said that if deposits of more than $25 were received by the bank while the bank was insolvent, that was a felony. I don't see anybody prosecuted for that by the previous administration or this administration. Also, everything that was done in the government was done by the politicians because the politicians wanted it that way. And if the government, like we have right now, is you have the Governor Rosselló, who appoints the Secretary of Justice, who decides who is prosecuted and who is not. That's called prosecutorial discretion, which is absolute, and nobody can force her to accuse anybody she doesn't want to accuse. That's a problem we have. We need people to go to jail. For example, there's an important recommendation. Financial reports have to be done by XYZ date. Great. What's the sanction? 20 years in jail. Great. And what if the Department of Justice decides, I'm not going to do anything? You got a problem there. I think we need to look at the government of Puerto Rico as a reflection of our society. And if we don't see it that way, we're not going anywhere. That's, I think, one of the major problems I have with the report.
First of all, my name's Alvin Velasquez. I'm here speaking only on behalf of SEIU and not any group, committee, or other organization with which SEIU may be affiliated. My first impression of the report, and I'm going to say this with all due respect and a little bit of colorful language, this report holds responsible and makes the same mistake as the USGAO audit report. It goes after the addicts and not the supplier. And what do I mean by that? The addicts, unfortunately, are the politicians in Puerto Rico who kept taking debt and debt and debt. However, as any prosecutor knows, you do not go after the guy on the street. You go after the guy in the mansion. Quite simply, there is no excuse, as I read this report, and given the bit that was put out there, that these underwriters should have allowed a lot of this debt to go to market. It is that simple. We already knew in 2014 that Puerto Rico could not pay its debt. Now, you might say, well, we're in Puerto Rico. Our favorite blood sport seems to be going after politicians and talking politics. That doesn't help the situation here. It is not useful for a bunch of reasons. It doesn't solve the problem. We have to bring money into the estate. You do that by filing the claims. And I would call on the board and hope that the board either appoints an independent trustee to go ahead and bring claims against the financial institutions that were responsible for this as the suppliers, or that it names a separate trustee or official committee to bring claims. But let me tell you, this report and the focus of it, and I say it's a well-done report. I got to say that, like, John and I were classmates in law school, and he did a great job in terms of the professional quality of the report. I just have a different viewpoint. That viewpoint that I have suggests here that we need to look at two things. One, of course, as you just heard me bring in affirmative litigation, and secondly, there is still indicias that the debt was issued ultra vires. Even in John's report, you hear talk of the swap termination fees. The swap termination fees were not included as part of the debt limit. There is an important part. Why didn't we include that? Why, for example, did we issue the 2013 PREPA bond using money from municipios, from cities that were supposed to pay electric bill contributions in lieu of taxes? Well, heck, Juan Bobo, my father, and everybody on the street knows that cities don't pay electricity to PREPA. It's a false receivable. So why is it that we use that receivable and say, we have enough money to pay for PREPA? And if I recall correctly, I don't remember the page in the report, but I remember there is a certain page in the report that says that the underwriters did not actually look into that issue. Okay, question. If even people who are not financial professionals get that, then how is it that the financial professionals missed it? That's my initial reaction with regard to the report.
Thank you, guys. You were very colorful, and actually you you pointed some of the points that we are going to, you mentioned some of the points we're going to discuss in the later discussion. Regarding the recommendations regarding the debt, I will throw my 3 points before you guys tell them and let you discuss them or discuss the ones you have. One of them, Alvin and John already mentioned, has to do with the constitutional limitation. The report mentions basically in a lot of detail the 15% limitation. It also mentions at a glance the one regarding the time, the 30, 40 per year issue, and also mentions the one regarding that we should have balanced budgets. And I concur with John, even if we have an opinion from the Secretary of Justice that says that we can take loans to balance the budget, it doesn't necessarily mean it's a good practice. I mean, if I have a job and I make $50,000 a year and I have to take a credit card every year for $10,000, after 10 years I will have at least $100,000 in debt, which I cannot pay. So I concur with you that something has to be done regarding the constitutional issue. John threw the idea of doing an amendment or something to the Constitution. The second point has to do with the elimination of the SILT, of the charge of the municipality. Again, we know we don't pay that. The thing I didn't show in the report is what's going to happen there, because, I mean, municipalities always say that if they eliminate the SILT, they are going to get more money from taxes. PREPA says it's otherwise, and I didn't see in the analysis what's going to happen economically if the SILT is eliminated. And my third point, and I speak with John a lot, sometimes we don't agree. I agree with you regarding the pre-issuance validation mechanism. I mean, you are going to issue some debt, and you hire attorneys and underwriters and CPAs and everybody else, and 40 people tell you that you can issue the debt. Now you're going to go to one judge, and he's going to look at that and say, no, don't do it. I mean, and maybe I don't understand the mechanism well. Maybe it's some specialist that only does that, and let's see where we can find that person. So that mechanism actually worries me a little bit, because I don't know how it's going to be implemented. And the other thing is, even if we have a local judge that says that debt is valid, if I bought the stock, the securities in New York, is that going to be binding for me? So with those 3 points, I open the floor for my colleagues to discuss.
Well, I'll jump in on the SILT. I think just as a matter of good administration, you should collect the taxes you're due, and you should pay the electricity you consume. I think the direct consequence of eliminating it would be that ballparks would be, the lights would be shut down at night. And you fly into Puerto Rico and you see all of these ballparks burning oil. It's absurd at 11, 12 at night. So I think municipalities need to be responsible for the electricity they consume, and they should manage that and find ways to be more efficient. And if that results that they end up with more revenue than the electricity that they pay, great for them. PREPA thinks it's otherwise. I think PREPA has a longer-term problem in terms of less population, more efficient energy consumption. PREPA is dead in the water many years ago as a business because they haven't faced the reality that they're swimming against the tide of technology and unfortunately of population growth too. So they have a lot bigger problems than the SILT.
Okay. Well, as mentioned, I really want to focus more on solutions. I guess we could be here all day talking about what happened and what didn't happen. But I think there's a consensus, and I'm very much in line with the findings of the independent investigator. High levels of government debt really basically distorts financial markets. Given the size of our economy, it crowds out private investments and even impacts our island's productivity, amongst other factors. And on behalf of the private sector coalition, we do have a number of recommendations looking forward to the future. And the first one is we want to establish a long-term economic development plan. And when I say long-term, it's a plan that could be decided for us. Short-term is 3 to 5 years, medium 6 to perhaps 15 years, and perhaps long-term up to 50 years, because we're really talking about the future of at least the next 2 generations of Puerto Ricans. And this plan must be the product of a collaborative effort of the government and non-governmental sector. And when we talk about the plan, we're talking about one plan, just the plan, because one of the problems we have is that there's so many things, so many plans going around, and we have to integrate them and align them in terms of the future economic growth of Puerto Rico. One of the very important items here is that we have to establish what we could call an economic council, which is a permanent multi-sectoral body, which could be to be led by non-governmental team, and that will serve as a sounding board and guides the economic development and evolution process in the medium and long term. And one of the principles should be inclusion. All citizens, everybody in Puerto Rico must be able to participate and ensure that it provides opportunities, this economic development plan for the island. And as obviously, as we have mentioned in the past, all this action has to be transparent and has to be communicated broadly to our citizens on the island. And obviously, I could go, there's a number of other elements, but I probably would go a little more into, because we have a specific economic model we will be present and will be shared with the committee and obviously on the public. In given and definitely would like to take among the other factors. One of the things we really seek is obviously there's a number of strategic sectors we want to focus on, and definitely take advantage of the local expertise in Puerto Rico, and which will also help to position and differentiate our island in the world markets, and definitely as our friends, one of our principal members of the coalitions, the Hecho en Puerto Rico, so we have to buy local. Definitely, we have to concentrate on local resources. But what I'll do is, in the next intervention, I'll go a little more in terms of specifics. I guess I want to take time for the other committee members. Thank you.
Okay. Most of my career, I've been what is called a plaintiff's lawyer. You hire me because you want to sue somebody. So I always look at things from that point of view. So what
That's an advertising. You have to pay for that.
Eventually, depends on the case. Well, the thing is that looking at what Kevin was mentioning, let's look at the validation. And the more I look at it, the less I like it. You have to do it before the issue is done, or before it's bought. So if nobody is buying, who's bound by it? If the guy is in New York is right next door, in Walla Walla, Washington, or Hawaii, where I was born, does the person know about Puerto Rico? He just knows that maybe his broker recommended it. What if today I don't have a penny to my name, but 3 years from now I hit the lotto and I have $10 million that I can buy? This process, to me, makes no sense. And I wanted to mention something and put things in perspective as to something that Alvin here mentioned. Today is September 18th. May the 3rd is the last day to file any claims by the government, by the Title III debtors against anyone. The board has an important job to do. It has to determine whether it's going to do it, how it's going to do it, etc. And if it doesn't do it, which I think it has the ability to determine yes or no, under Section 926 of the Bankruptcy Code, there's other entities who may do it. And we have to give a chance to those other entities if they believe there's a cause of action. So time is short. We need to do this quickly.
You know, I just wanted to react to one small point. I think it's one thing that's easy to do here is beat up on PREPA. It's also pretty popular, almost as popular as beating up on politicians. But I think we got to be really clear about something when we look about going to the markets again, and that's looking at the role of the credit rating agencies and with regard to what they did. I think there was an omission in the report that I saw that I think needs to be mentioned in terms of bringing sanity back, is looking at the ratings. The reason is because the 2013 PREPA bonds were rated as investment grade. Now, I find that very curious, and the reason I find that very curious is because there was a California utility with stronger financials that got a junk rating at the same exact time as the PREPA 2013 power bonds. In other words, while it's easy to point fingers here, we have to look at macroeconomic and macro outside factors that affect the appetite for investors to do so, to purchase the bonds. I think to John's point, he made a good point about the validation proceedings. I would probably differ with him on some of that point, and the reason, respectfully so. The reason is The debt if you look at the states that have debt validation proceedings, speaking of Washington, Walla Walla, Washington has one. Oklahoma has one, okay? Ohio has one. A lot of the states that have debt validation proceedings are states with stronger credit. And the reason is because before they go to market, there isn't a judicial opinion, and those bonds are governed by that forum's laws. I think that I agree with John 100% that if you are going to have a debt validation proceeding, then the civil code and other debt, and I'm not pretending to be a Puerto Rico lawyer, so let me go there.
But you're doing good.
I'm trying. I'll speak in Spanish, but you don't want me to do that. But the real issue is that you have a lack of taxpayer standing, and that is a huge part of the necessity of transparency. We don't have transparency because we've locked out the public out of the legislative role, sometimes out of the stuff that happens at the executive level, just because we don't have, the rulemaking happens differently here. And not only that, but at the judicial level. Now, believe it or not, most states have an exemption for taxpayer standing for debt validation proceedings. I think in Puerto Rico, it makes a lot of sense because it gives a forum for the pueblo to say something.
Regarding the debt, and I mean, and I saw recommendations, and I like a lot of them, but my biggest concern, and I think it's something, I think is what John who mentioned, that we already have some mechanisms and some safe harbors here. So it's just a matter more of having the will or that actually take a step. So what we can do, actually, when I was preparing for this meeting, I got a letter from 1975. I was discussing that with Ramon Ponte when I was coming here, and some of you guys have seen it, where they are saying, and I will go to Spanish here, es evidente, sin embargo, que cualquier política que no esté dirigida a traer bajo control la posición frágil en que nos encontramos pondrá en serio peligro el financiamiento de los programas del Estado Libre Asociado. De hecho, puede que ya sea tarde. This is from 1975. So 44 years ago, 43 years ago, and actually at that point in time we had, I think, close to $5 billion in debt, not 72, 70, whatever the number is right now. We already had the concerns here. Actually, the letter, I think I mentioned, is from Guillermo Rodríguez Benítez from Banco Gubernamental de Fomento to Rafael Hernández Colón, who was the governor in 1975. We already had the problems, and we already, I think, had the mechanisms, but we did nothing. And actually, the guy was right, 43 years.
That's the same year, 1975, that the famous Tobin report was issued. So starting probably 20 or more different economic studies will be done in the past. So we've been at this over 2-3 decades.
But that's my point. I mean, what can we do? Because, I mean, I like the recommendations. They are good, but unless they are enforced, we're not going to get anywhere. And as Ramon pointed at the beginning, we'll be here in 40 years. I hope to be here in 40 years speaking about this.
I won't be here.
At least we have a video of the.
I think the main problem we have is we go back to Edmund Burke. The only thing that evil needs to triumph is for good men to do nothing. On the other hand, we have the Constitution, and if men were angels, we would need governments. That's why I insist in that we need a constitutional convention in which we tighten up all the loose ends that we have in the Constitution that the not good men have been doing for 40, 50 years, and we need to deal with that. And we need to make politicians, and not only politicians, but people in the administrations that are not elected, accountable for the things they do. And people need to go to jail, not necessarily in the federal court. We need people in state court. We need the state Department of Justice to do things, to enforce the laws, not to just talk about them.
Well, John, but going back to one of your points, I think a lot of what politicians do, it's in reaction to what their constituents are asking for.
I agree.
And some of the long-term problems, some of the problems we have are really long-term problems. We've known them for many years. Certainly the pension issue is one that has been there for a long time. And some governments have tried maybe timidly to address the structural problems. You had Law 7 and the CAREF at the beginning of Fortuño administration, Law 66 at the beginning of Garcia Padilla's administration. And what you found was a big uproar against the government and a pushback against some of the actions. And politicians being politicians, well, they reacted, to try to get reelected rather than to try to fix the problems.
I've got to disagree with that. I'm sorry. I proudly work for the 25,000 members of SEIU. I'm going to sound like a syndicalista for a second. In Puerto Rico, as a matter of head count, Puerto Rico's government is actually not too big. If you count it against the rest of the United States, per capita, Puerto Rico's government is the size of Wyoming's. And nobody's accusing Wyoming of being the People's Republic, just to be really clear. Secondly, again, when we look at the issues, we have to look at the enablers. We have to look at how we got here. I'm not going to take an opinion or issue with regard to, the Constitution, say that I don't live here. I come here all the time, but I don't live here, and I respect, people of Puerto Rico's ability to make their decisions on that very key issue. But if we look at Law 7, if we look at Law 66, if we look at all of that, that's Greece, people, and we're still here. We have a major debt overhang. The debt has to be reduced. We have tools to do it, including the PROMESA proceedings, including the ability to look at the financial realities and the distinction and the kind of mechanisms that were made to go around the debt. And we have refused to actually go and start trying to figure out how to devalidate certain bonds that are questionable. And the fact that they were these questions about the legitimacy of the bonds were raised for 30 years, 20 years, is craziness. I mean, I look at the fact that, people were attacking the idea that some debt could be issued ultra vires. And now it's a topic of common discussion. It's finally become okay to say the emperor probably has no clothes, right? I mean, that's kind of what's happened here. And I would say that the real issue with regards to looking into how to fix this in the near term is we have to look at subordinating the debt, okay? And that's bankruptcy talk for it has to be declared ultra vires were appropriate. The report from Kobre and Kim gives a manner of how to do that in terms that's still covered under the statute of limitations, because if you do something ultra vires, guess what? The statute of limitations doesn't apply because it acts like it never happened. We have to look at those processes, bring those processes in PROMESA, and bring the claims. And again, I really hope that's where the board goes, but I think that's the direction we have to go in the near term.
Mr. Moderator, you got some questions from this side, too.
Oh, okay.
Certainly.
Just to continue what I think, Alvin, your analysis of the addict and the supplier. And I don't think that's a false analogy. I mean, I think that's real. But by the same token, I don't think you can, to continue the analogy, I don't think you can have a successful drug abuse prevention program without both the supplier and the addict being addressed. And I think the report does provide some mechanism to address both the supplier of the funds as well as the user of the funds and possibly overuser of the funds. So I think that analogy, I mean, in all of this, it seems to me, and you may disagree, that the one thing the report should trigger once the dust settles is the importance of being reflective. People really need to look and see what has happened, and forget for the moment who may be culpable. But what actions are going on within the confines of the Commonwealth that can be controlled, that should be controlled?
So I think there's definitely a couple of things. The really easy answer, as far as I'm concerned, is Puerto Rico should comply with its own constitution. I mean, It's as simple as that sounds. What's unique, so Puerto Rico's constitution, you've heard over and over, has a 30-year swap, a 30-year limit on
Limitation.
geo debt, right, limitation, a 15% debt limit on those that are considered covered by the Treasury, and it has some fancy definitions. And then thirdly, you've heard it said that we have a balanced budget clause that, I would say if we had a balanced budget clause, we all wouldn't be here. I'd probably be at home having lunch right now. Like, really, it defies expectation. What's distinct, Judge, with Puerto Rico is that it has all three. Other states don't have that. Other states will have, for example, a balanced budget clause, a 15% debt limit. Like, for example, the state of Washington's debt limit is very similar. I think if you bring all the blend, to use audit terms, if you look at the blended, and you know, CPAs will correct me here, I'm sure. If you look at the blended component units, you have to look at all of those as going against the general fund and comply and calculate the debt limit, including anything that is from the general fund, or, because COFINA, you know, is cute that way, the taxing power of the Commonwealth. You know, we'll leave aside Prepa and Prasa because those are, you know, enterprises. I think that that's a major start to get going. And then I think that, you know, Cobre and Kim's report does make some very positive prospective recommendations insofar as it talks about the, you know, the bond validation proceedings, the protection for investors, strengthening OCF, right, and giving it more independence. I think those are all things that are good, but I don't think we can get beyond, like, and at least the members I talk to and family I talk to are livid about what's happened. And they're saying, Alvin, when are we going to get something that works here? And I think there's a bit of, you can't get onto the perspective part without getting some healing on some of the past part. And I think, I would agree, though, that there's both sides, and I want to acknowledge that. And I appreciate your point, Judge Gonzalez.
I'd like to comment on your question because I was impacted by the statement from the analyst, or from the, he said the situation is catastrophic. And I know there's plenty of blame to go around, but definitely we're at a stage we cannot really afford these mistakes again. And that's why we can blame the politicians, we can blame even they could call it speculators, I guess, and in the markets. But in reality, it goes down to the individual. There's a lot of individual responsibility in terms of even the citizens, and specifically we were representing the private sector. The private sector has for too long been passive. We basically don't take any posture. Or basically, we obviously it's very easy to criticize the government, what they're doing and not doing. But definitely, that's why we want to look towards the future. And in fact, we talk about something called advanced citizenship, and we have to train our leaders looking to the future. And that's why we're very optimistic. But definitely, we have to change course. And but this is my personal, and I guess and this is I share perhaps the both outlooks, that even though we go through this analysis, there's really no consequences. Nobody's paying for the situation, and perhaps there should be consequences in the way that this mistakes will not be repeated again.
Yeah, I would like to add something. I think the constitutional limits are good, and if they can be strengthened, that'd be great. But I think we need controls. I mean, you can balance a budget with over-optimistic revenue projections, as the government did for many years. You can have multi-year appropriations that get spent when there's no money to go around to pay for them. So you really need controls and processes that prevent the government from overspending. You need real oversight by the legislature over revenue estimates that kept being over optimistic year after year after year. So you need really procedures and controls in the processes, as well as limitations that can help too.
I will use that as a segue to the final part of the question we have to do with government management, to governance of the island, because actually And I thought the recommendations were very good regarding the CFO. Contrary to John, now we are going to disagree, John, again, as usual. I like the financial statements issuance date idea, where they say that after 6 months of closing the year, you have to issue financial statements for the government. I also, and I mean, it concerns me because the report identifies weaknesses in treasury sites, in the Office of Ethics, in the component units, because they say they have too much discretion and too little coordination with central government. And also it makes a lot of comments regarding PREPA, which, I mean, as you guys mentioned, is a low-hanging fruit. But what I think is a very crucial low-hanging fruit, in the sense that PREPA, whenever you ask somebody about their concerns about competitiveness in the island, the cost of energy, it's a thing that worries a lot of people. There has been a lot of talks and a lot of actions trying to move PREPA along, and quite honestly, I don't think they are moving as fast as I would like. So with that, I leave that to my colleagues.
Well, on the first point, Kenneth, I think you should talk to your audit partners about that. I'd be very careful about putting hard and fast dates on a process that's really supposed to be done by an independent auditor. If you're putting undue pressure on someone to finish their professional job, I think that can be very dangerous. I'd like to just quote Yogi Berra with respect to an audit: the audit's not over until it's over. And unfortunately, that's
what happened with 2015.
You can put
And 2014
you'll get
PMP.
qualified. You can get qualified opinions. So I'm not validating the processes, but you have to be careful about setting a date so specific and so far away from our reality. But I just a point of caution there.
Remember, my old boss used to say, "Accuracy first, speed second," but not,
Well, no, I
but
think
not
it
very,
can
but not
balance.
very,
It can balance.
not very far second. He'd say.
No, and certainly agree, and we can talk a lot about that topic. But
Vísteme
just a note
despacio,
of- a
que
note
voy
of care.
deprisa.
Definitivo.
And you can get an opinion with a lot of qualifications, and then you'll be asking why, and the auditors are writing what they write. But
20 years ago, they were issued on time.
and they can be. No, I'm not validating that they, and certainly the current circumstances are very different from 20 years ago, and that counts too. And we can talk about the process, but I think the typical deadline for the CAFR, and you have a lot of component units. It's a complex audit, and you can have bits and pieces of them done within the 6 months, and I think they are. But the whole consolidated process certainly needs to have a lot of accounting infrastructure built in first, so that you can first get there. So that's why I'm saying you can't just say, well, it gets done in 6 months. You need to really build the systems and the processes so that it can be done accurately and in time.
I think
I've got something to say about audits. I think you were talking about the 6 month thing. I think something that's really important, though, is even the prior financials with regard to, for example, debt compliance got it somewhat wrong in this regard. If you look at the KPMG reports from 2012, 2013, KFIRS, they certify that Puerto Rico had met its constitutional debt limit. Then if you look at the 2014, there's a footnote, if I recall, on page 15 or 16, that says, actually, we're not going to any longer certify that Puerto Rico has complied with its debt limit, right? And they leave it as an open question. I think that shows an example of, even after having done it for so often, and even though sometimes audit procedures are automated, that there's room for reconsideration. So I think with regards to, speed versus not speed, I think either which way, we've shown that there's a history of revising and relooking at issues. Secondly, in terms of audit functions, I think that one issue with the report is it didn't distinguish between the various audit functions, and I think it's pretty important to get this right, because obviously there's compliance function, there's a financial function, there's a forensic function, and there's a performance function. I think in terms of PREPA and other utilities, I would encourage the Commonwealth in the future to get frequent performance performance audits. And the reason for that is because a financial audit will give you a limited amount of feedback in terms of controls and things to improve. But I think at this point, what we're going to need, especially as you guys are constructing a fiscal plan going forward, is robust mechanisms to make sure that standards are met with, and a very constant review of how performance is being met and what can be improved.
I think I think there are 2 points in the report that address that, I believe. And the two are, one is the rotation of auditors slows down the process, which when a different regime comes in power, auditors change. And that in and of itself causes significant delay. And the second is the enhancement of mechanisms for accounting that speak to one another, so things can be done efficiently. And therein lies another situation where, at least at a public meeting, it was explained when a new government comes in, sometimes or often, the technical people put in charge of making that happen change over as well. So you have this constant starting, stopping, changeover, and at the end of the day, it is often delayed significantly or hasn't occurred at all.
That's true. That's something that happens, and I mean, we have seen that. And you have strange things like, for example, in Treasury Department, at some point in time, they had, I think it was 3 systems at the same time, and they didn't communicate among themselves, so your information could be in one of the 3 systems. That doesn't make any sense, and that's only one agency. So when you replicate that in a lot of agencies, and as Ramon pointed out, that you have to consolidate with all of them, and there's not a lot of coordination. That's a point that actually it's made in the report in page 236. Yeah, you will not be able to issue that on time at all.
Yeah. I had a little comment, Kevin, on which, by the way, I do agree with you with the time limits, with the caveats that Ramon has mentioned. PREPA. I think that's, to me, it's like the best example of the problems that we have to transform the government. When you look at the law for the sale of PREPA, when you read it thoroughly a couple of times, you notice they don't want to sell PREPA. The politicians don't want to. When you have the legislature having the last call on when it's going to be sold, when you hear the questions when the panels before the legislature, how much is PREPA worth? One thing is what the books say, and another thing quite different is what people will pay for it. So I don't think politicians want to get rid of anything. They have to be forced to get rid of it, and that, of course, is where the board comes in. So I hope you, as Mr. Carrion said in one venue, I think it was in the Commerce,
Chamber of Commerce.
Chamber of Commerce, and he said that PREPA had to be sold. I almost got up and applauded, and I agree with him on that.
A quick comment, just more as a business person, we need transparency, total transparency, and this was obviously the situation, as the judge mentioned, continuity. We changed direction.
They are putting in place the CFO office, which now Raul Maldonado also heads. I think that's a good initiative, and I think that those are good steps towards that direction, in my eyes.
Yeah, I mean, with respect to the recommendations in general, I think if you look at the history of recommendations that the Colegio de Contadores has made over the years, you'll find a number of them have been there for many years, including the elimination of the SILT and others on government systems and the like. So,
I think they're making us signings that we should try to wrap up. Any?
But we got a couple questions.
So
We'll roll the timeline if that's all right.
Okay. Okay.
Although they may be a little in the wrap-up category. I just want to make a quick little set of comments. A lot of what I've been hearing y'all saying is there should be more focus on causes of action and the debt limits and those kinds of issues. Was one point I hear a lot. And the second point I hear a lot is controls going forward. So just a comment on each of those. On the causes of action, that wasn't the purpose of this report. The purpose, as you know, and Alvin made this comment, the purpose of the report is diagnostic, to try to figure out what went wrong, what potential causes of action are, and what could be done going forward. We are now in the mode there's a new committee that happens to consist of all three of us, plus Andrew Biggs, that is looking at causes of action. And so we will be making decisions on all of these issues that we've talked about, debt limit issues, other potential causes of action. The other comment I'll make is on the controls. Obviously, in the report, there is a lot on that, on recommendations for what might be done to try to prevent this kind of a crisis from reemerging. I'm hearing from y'all there's even more we can be doing, and we hear the message.
Thank you.
Just a couple more things from me. I think following up on David's points, much discussion has been and issues have been raised around potential claims and next steps. And I just wanted to mention that as raised in the report, and many of these issues are already part of litigation. Issues like the structure of the ERS bonds and and there's been a recent ruling on that matter and on the extent to and on the shift to PAYGO. Similarly, issues around the validity of the 2014 offerings and whether it was done in excess of the debt limit. So many of these issues are going to be looked at by the special committee, are going to be considered by others, and through the restructuring process will be raised. And as John and Alvin both mentioned, time is of the essence. Hence our appreciation for Kobre and Kim doing such a comprehensive job and doing it on a timely basis to be able to fit with the timelines for bringing these issues forward. Just one thought on I come from here, but I live in a place and have done budgeting work in a place that has voter approval for bonds, as well as validation proceedings, though not required for everything, as well as taxpayer standing. And just one thing that I would bring to, and I tend to think that the more oversight and the more attention for these processes, the better, because when one is entering a commitment that is as long-term as this one, it's important that one do so with full knowledge and with the ability to honor said commitments. But one thing to think about on the validation processes is that part of what they do is they slow things down. And so thus there ends up being an interaction between a validation process, particularly coupled with taxpayer standing, and the possibility of doing deficit financing, in that frequently the process is not resolved before you go to enact the future budget. So in effect, it ends up becoming a constraint on the extent to which bonds and long-term indebtedness is used to finance short-term deficits. So anyway, I just as you think about different things, because these recommendations really, as Kobre and Kim has noted, part of it is our collective role. A lot of it is for the government of Puerto Rico to decide, and for the people of Puerto Rico to decide on a going forward basis, is some of these things and how they work together. It's important to think about them in that way. So anyway, just a few points, and thank you for your words and for your succinctness in your comments.
Thank you.
You may be the moderator extraordinaire going forward.
As long as he has the
That's a good.
battle.
I don't know if that's a good or a bad problem to have. And I mean, we are all the same boat here. I mean, we want this to be solved. And when I say I want to be here in 40 years, is looking back and saying how we got out of this, not that we are still stuck in the same situation. I think private sector, government, everybody should try to get out of this. I mean, it's a very unpleasant, sad situation. We are aware of that, and it's a painful situation. So, I mean, the sooner we can see the light at the end of the tunnel, I think much better.
I was going to say, Anna, just something you said that really triggered for me was, you guys on the oversight board have so many things that I don't even want to pretend I know what your agenda schedules look like at a daily basis, and you guys are on a volunteer basis. I would just as I think through the issues, I've pushed the idea of looking at, having an independent trustee or something like that, right? Somebody different whose main job is going to be pursuing claims to appoint someone like that. Part of the reason that I would encourage you is, from an operational efficiency standpoint, insofar as, right, there's already a lot, I'm sure the Cobre and Kim report took a lot of time to oversee and to work through. I think it would be really important to make sure that whoever, if I would encourage you to appoint somebody, and that whoever that is somebody whose only job is to just, basically pursue claims like a police dog, basically, as appropriate, but in terms of going for those, just because I think that there's already going to be a lot of complexity in and I'm not a bankruptcy lawyer, this is what I hear out in the world, right, is plans of adjustment are complicated, they're going to go crazy, right? It's important to I think it would be good to cabin off that part. And my understanding is that sometimes that's done in bankruptcy, like Judge Gonzalez and Professor Gill, and I'm sure you guys probably know that better than I, and just to keep that as from an efficiency standpoint as well.
We have 4 minutes, so I mean, one for each.
Just one point as to what Ms. Matos Santos mentioned. Since we're using the attic thing, yes, you're absolutely right. It will take longer and it is more difficult, but that, I think, is precisely the beauty of it. Puerto Rico is addicted to taking loans, so let's limit the ability to take loans.
That was my point.
Yeah.
It does that.
I don't know if I use that same analogy. We have to go through cold turkey, I guess. We're doing that. No, but I think in terms of the people I represent, the private sector coalition, definitely we want to look forward, as mentioned, Kenneth was mentioning, and we want to be part of the solution. And definitely Puerto Rico in the future could be a place to attract people, talent from all over the world to live, work, and play. It's a very, 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 very good environment. So I definitely, we could be all day talking about blaming people, but definitely we have to take these steps, concrete steps, for not repeat this same problems of the past.
I just reemphasize my initial point. I think we need to look at both sides of this, look at claims and where necessary, put responsibility, financial responsibility on whoever didn't do his job right. But we have to put the procedures in place to make sure we don't end up in the same place again.
Any questions from the board? Thank you to the panel. Thank you to the board for hearing us. I mean, we always complain that the private sector doesn't get a seat on the chair, so I'm glad you guys prove us wrong. Have a great day, and thanks for the opportunity.
Thank you.
Thanks. And I'll just thank Cobre and Kim again for all the work they did on the report, and thanks to our moderator and panel for a very, very informative discussion. And just repeating what Anna said, y'all were great about time, making very important points without talking at great length. It was a model of how a panel should operate. So thanks, everybody. I wasn't going to be able to keep up with the analogy of the best much further.
Ok. Español. Sí.
Spanglish también funciona.
Sí, buenas tardes. Es que quería preguntar, y yo llegué un poquito tarde, no sé si eso se discutió, pero quería preguntar sobre una preocupación que ha existido durante toda esta situación de la discusión de la deuda, y es el issue de que, por ejemplo, en el caso del Banco Gubernamental de Fomento, en el Debt Adjustment Plan se quiera eximir o exonerar a los oficiales o al propio banco de cualquier reclamación que pueda haber en un futuro. Dado el caso de que el Banco Gubernamental de Fomento fue el ente fiscal del gobierno durante varios años, durante casi 10 años, quería preguntarles si ustedes van a imponer, si la Junta va a imponer límites en términos, y qué límites van a imponer en términos de las reclamaciones contra el BGF en específico.
Nuestro colega David va a contestar esta pregunta.
Will this work? Or should I use this?
Yeah, that one.
Thank you for asking that question. It's a very important question, and it's one that people have been talking about a lot recently. There's a bit of confusion, I think, in people's understanding about the scope of the potential GDB releases. The scope, and this is something that we've looked into very carefully and have been concerned about, the scope is quite narrow. The releases do not release former executives of GDB. They do not release any of the professionals, any of the banks, any of the lawyers or accountants. The releases only apply to current employees of the GDB, or they will only apply to current employees of GDB. And the idea is they should be protected for the current restructuring process. It's a very standard thing in a restructuring, at the end of the restructuring, to provide a release to the people involved in the restructuring. But the release does not apply to former GDB officers or employees. It does not apply to professionals, to banks that represented the GDB. So it's a very narrow release. And as I said, it's something that we have looked into very carefully. A FOF filed a pleading in the Title III case yesterday indicating, or I think they filed it yesterday, they were planning on filing it yesterday, indicating this scope of the release, so the narrow scope of the release.
Cyber News.
¿Por qué en estas vistas que se están dando y en este informe que se preparó no se va o si la habrá consecuencias para las personas involucradas en toda esta situación? Porque básicamente la solicitud que se había hecho sobre esa investigación era para que los responsables asumieran su culpa.
I can take that one. La meta del informe tiene menos que ver con culpabilidad y más con los hechos. A nosotros lo que nos tocó, la meta, era identificar para el público los hechos relevantes a la crisis financiera y dejar para ese público y los políticos que lo representan la meta de responsabilidad. Así que nosotros cumplimos con la meta en hacerle saber al pueblo y al público la base por la cual quizás en un momento futuro habrá responsabilidad tanto en el marco civil como en el marco regulatorio. Pero para nosotros la meta fue y siempre será, ¿no?, los hechos, establecer los hechos.
Noticentro.
Entonces, justamente... Bueno, sí. Entonces, la finalidad del informe es una cosa, que va a ser el comité con los hallazgos de ese informe, si se va a mirar la posibilidad de adjudicar responsabilidades hacia el referido si fuera necesario o si fuera el caso. Y quisiera además que hablen en particular sobre la relación de un pasado presidente del banco justamente en la Junta mientras se está investigando pues las actuaciones del banco.
El comité independiente que se ha creado, que es diferente que el comité independiente que trabajó esta evaluación, esta reinvestigación y reporte, ahora va a tomar todos los hallazgos del trabajo que se hizo, que hizo Cobra & Kim, y vamos a evaluar toda la información, evaluar qué hace sentido, cómo debemos de proceder, qué cosas le toca al comité moverse con ellos y qué cosas son cosas que puede atender otra gente. David, anything you'd add on that matter in terms of the process and steps going forward?
I would just reinforce exactly what Anna said. The first phase of this investigation was diagnostic. We were trying to determine what the facts are, why Puerto Rico is in such a bad financial predicament and has been. Are there causes of action against people involved in various ways? and what can be done to make sure this never happens again. And so that was the first stage. We're now at this stage with a new committee that has 3 of the same members, plus Andrew Biggs. It has 4 members of the Oversight Board, to look at the findings of the report and determine what causes of action should we bring, what should we do in the Title III case, based on the information in the report. So that's what we're doing right now going forward. It was mentioned earlier that we have a few more months to do it. Many of the causes of action have to be brought within 2 years of the Title III filing, which was May of last year, so we have until May of next year. But that's exactly what we're doing now, and the focus is going to be on, are there causes of action that can bring in money to help with the restructuring process?
Primera hora.
Sí, muchas gracias. En el reporte de los señalamientos, constantemente, a través de todo lo que presentaron, se señala el problema de la intromisión política, en tomas de decisiones erróneas que llevaron a todo esto, y que eso no sorprende a nadie, ¿no? Y nuevamente en las recomendaciones constantemente se habla de limitar ese alcance de la participación política, la intromisión política, y de hacerlo más transparente, con más participación de mucha gente. La pregunta, por supuesto, ¿qué pasos se podrían dar para lograr eso? Porque nada, ahora mismo seguimos en la misma situación. Está todo controlado por decisiones políticas, a veces pues para favorecer intereses políticos nada más.
Yo creo que los puntos que hizo Arthur sobre esto, en términos de que es un momento de pensar sobre cómo hemos llegado a este momento de estudiar el universo de la evaluación e investigación que se ha llegado aquí, y qué son las cosas que le tocan al comité, qué son las cosas que son más allá de eso. Yo creo que es importante que hay líderes cívicos, líderes de la empresa privada, que hablan de la importancia de tener más transparencia y de tener diferentes controles para asegurarnos que este tipo de cosas no pase. Y yo creo que muchas de la discusión en términos de que es importante trabajar toda la estructura, trabajar todas las diferentes cosas que llegan a una posición en la cual se puede darle largo al asunto y no resolver y atender los asuntos que hay que resolver, asegurarse que el presupuesto esté balanceado, coger demasiado dinero prestado. O sea, una cosa que me chocó a mí mucho cuando empecé en este desempeño es que la economía de California, cuando yo estaba trabajando en el presupuesto allá, eran como 2 trillones de dólares. Y la deuda que fue como el equivalente de Cofina que California hizo es básicamente al mismo nivel de dólares que Cofina. Eran 19 menos 17 y medio. Una economía de 70 GNP de billones versus 2 trillones. Ese sistema que lleva a un nivel de deudas tan alto, pues hay que atenderlo, y es parte o sea, aquí hay un informe, una investigación que miró todo, o sea, y tenemos que en realidad prestar atención a eso, y parte es trabajo de nosotros, parte es del trabajo del gobierno y parte es del trabajo de todo puertorriqueño para asegurarnos que se hagan los cambios, no solo para trabajar con la situación en la que nos encontramos, sino que para hacer los cambios que van a hacer la diferencia para el futuro.
Reorg.
Can I add just one small thing to that, and really just reinforcing what Anna said? There are many things we can't change. We can't require that there be consistency in auditors and the auditor not change every time there's a new political administration. But our hope is that this report, by shining a light on that, will reinforce the people in Puerto Rico who are trying to make sure that doesn't continue to happen. So hopefully the report will provide credibility and reinforcement to reform efforts on the ground, and I think that's an important part of the role.
Reorg, John Marino.
Yeah, I'm just wondering if you could give us a better, more clear idea of your agenda moving forward, this new committee. Will you issue a report? Is there kind of a deadline to wrap up your work? And will your analysis on potential claims, will that include, whether certain debt issuances were valid or not? And will you consider this suggestion that a full-time claims trustee be appointed? Thanks.
I can at least start with that. So one answer would be we don't know, because the new committee was just formed and this is the end of the first phase. So we will have to talk about that. Just speaking for myself, I'm not assuming that we will issue another report. I mean, I would assume that what we will do is we will look at this report, look into potential causes of action, and act on them in the Title III. But we haven't talked about that. So it's possible we'll issue some sort of statement about what we've concluded and what we'll go forward with. But I think it's at least as likely that we will simply act. We will bring litigation where we think it's appropriate. We will bring motions in the Title III case where we think it's appropriate.
And we will act with deliberate speed because we are well aware of the clock that we're working on there.
Telenoticias.
And will that include whether debt issuances were valid or not? Is that part of the analysis?
That is something we'll have to look into. It's a serious issue that many people have raised, and we'll be looking into all of the variables on it. How much is it going to cost to pursue? What is the likelihood we can succeed with litigation? What would the benefit of the litigation be? We have to look into all of those things. But where there is a strong cause of action that could mean real value for the restructuring, I expect us to move forward.
Hablando de acciones políticas con implicaciones fiscales, el gobernador anunció ayer que reduce las multas del AutoExpreso de $50 a $15 y que cancela las multas impuestas hasta el momento, hasta el día de ayer. Eso obviamente tiene implicaciones fiscales. ¿Qué va a hacer la Junta con eso?
La Junta está evaluando eso y eso es un asunto que vendrá entre la Junta en pleno, no el subcomité.
Ricardo Cortés, El Nuevo Día.
Pues, de algún modo lo que mencionan en el reporte tendría la capacidad de alterar la prioridad en el repago de la deuda o la prioridad que tendrían los acreedores de recobrar lo adeudado. Y bueno, la otra pregunta ya la hicieron.
So that is one of the issues. I mean, that is when I talk about possible causes of action, possible things that we might do in the Title III restructuring. That is the sort of thing that we will look into. Are there issues of priority? And we've already been litigating some of these issues in the Title III. As Anna mentioned, there's been litigation along these lines in the ERS with respect to the ERS bond. So that issue, the issue of priority, the issue of validity, those are all issues that we will be looking into.
Mayra, Canal 6.
Sí, para la señora Ana Matos Santos, yo sé que ya lo contestaron, pero para tenerlo en español, un poco el público lo que estaba esperando era algún resultado concreto en términos de acciones futuras, ¿verdad? La Constitución ofrece garantías, hay leyes, hay todo tipo de regulación y sin embargo llegamos a ese nivel de deuda. ¿Habrá acción posible para recobrar dinero, para encauzar a alguien luego del análisis que hagan de este informe?
El informe, la investigación provee la base. Ahora el comité que se ha creado va a evaluar los diferentes asuntos que han surgido y va a decidir cuál es la manera en la cual se debe de continuar el trabajo que se está haciendo. En algunos casos tal vez se llevarán acciones, en algunos otros casos tal vez son referidos, algunos casos tal vez son recomendaciones para consideración de cambios a las leyes de Puerto Rico y diferentes controles, así que esto es parte del proceso pero va a venir, o sea, el trabajo continúa y el próximo paso es que el subcomité evalúe la investigación y evalúe los diferentes asuntos que se han levantado a través de este informe y decida cuál es el próximo paso. Y muchos de los asuntos que se han levantado también ya se están litigando. O sea, por ejemplo, en el caso del sistema de retiro, en el caso de bono de transportación y diferentes otras áreas, algunos de estos asuntos ya han surgido y están ante la jueza Taylor Swain.
Centro de Periodismo Investigativo.
Sí, buenos días. Rapidito, primero, entiendo que esto es una investigación formal. Según el protocolo que aprobó la Junta, el investigador hace una recomendación de hallazgos de misconduct or not. Quiero saber si eso ocurrió. Lo segundo es, toda la documentación que recopiló el investigador no es pública y ustedes han, ¿verdad?, levantado el issue de transparencia. Sin embargo, gran parte, básicamente toda la documentación está no siendo compartida, no ha sido divulgada. ¿Cuál es el proceso que va a seguir la Junta para hacer esa información pública? Y por último, hay otros esfuerzos independientes de grupos como el Frente Ciudadano para la Auditoría de la Deuda que han impulsado. Se le preguntó una vez a Yaresco si ella apoyaba este tipo de esfuerzos o pensaba que podía coexistir con lo que ustedes han hecho y me dijo que tenían que esperar el informe. Una vez ya este informe está fuera, ¿por qué la Junta no apoya a la Junta estos esfuerzos para que se conduzcan investigaciones paralelas a lo que ustedes están haciendo?
John, si tú puedes atender el asunto número 1 y el segundo y nosotros hablaremos del tercero.
Perfecto. Pues el informe que se ha redactado para mí habla tanto como las decisiones tomadas a nivel de personas humanas, tanto como las estructuras que hicieron en su momento, relevante o no, las decisiones tomadas por seres humanos. Así que para mí el informe, y es muy difícil de hacer un resumen fuera de lo que hemos ya dicho públicamente de esas estructuras. Es decir, para mí hemos cumplido con la meta de identificar qué tipo de decisión se pudo tomar, en qué campo de libertad tuvo en su momento cada gobierno o cada entidad al emitir bonos o a...
Did you issue any findings of misconduct? That was my question. If you issue a finding of misconduct to the board or to this committee with your investigation, as a formal investigation pursuant to the protocol.
No, entiendo la pregunta y lo que digo es que el informe es la respuesta. The report speaks for itself about what degree of misconduct we found and what degree of purposeful or structural misconduct there was. So I think, you can read the sections on the way the Office of Government Ethics in Puerto Rico has worked historically and how it should work going forward, or how it might work differently going forward. The individual, if you're looking for sort of a summary of which decision makers had authority, I would direct you to the report, which I think speaks for itself. We didn't find, if there were a smoking gun, right, if there was a clear sort of bank robbery situation, you probably wouldn't have needed us. This is a complicated story that involved structures that over time incentivized certain decisions that landed Puerto Rico where it is. So that's one question, I guess. You wanted to know a little bit about the documents that were gathered, the evidence that was gathered. Ok, está bien. La pregunta segunda era, ¿qué de las pruebas que nosotros pudimos ubicar? ¿Dónde es que se hallan ahora? Y la respuesta es que la Corte ha expuesto un proceso para cómo se otorga a varias partes todas las pruebas que se reunieron para basar, en los cuales se basa nuestro informe. Y esa orden, ese dictamen de la Corte, the Exit Procedures Order, dicta cómo es que partes, tanto en el público como partes que quizás podrán tener un interés en un litigio, pueden acudir a la Corte para acceso a esas pruebas. Y es un sistema, todas esas pruebas quedarán disponibles y la fuente es la Corte. Ahora nosotros casi nuestro papel se ha concluido y las pruebas que dejamos detrás de nuestro esfuerzo están disponibles para el recurso de esas partes.
La pregunta del apoyo a los otros esfuerzos que hay para la auditoría de la deuda.
O sea, ahora mismo, o sea, número uno, que lo más importante es que se ha hecho una investigación bien amplia donde se miró en todos los diferentes recovecos de cómo fue que llegamos a este momento, cuáles son los procedimientos, o sea, para qué se emitieron los diferentes bonos. Se han levantado asuntos como, por ejemplo, que en el caso de energía eléctrica se emitieron bonos y no se usaron para la razón por la cual se emitieron. Se levantaron diferentes asuntos sobre cómo trabajan los bond trustees o no trabajaban los bond trustees en términos de issues de seguimiento. Se levantaron asuntos y se habla de diferentes asuntos sobre que ya están ante la Corte sobre si alguna de la deuda se emitió en exceso de los límites constitucionales. O sea que se ha hecho una examinación bien amplia de todas las diferentes, de dónde nos encontramos y por qué nos encontramos en donde estamos. Y el próximo paso aquí es la evaluación del nuevo subcomité para ver cuáles son, o sea, qué asuntos se refieren, qué asuntos el subcomité lleva adelante y cuál es el rol de otras entidades que pueden tomar acción en base a la investigación que se ha hecho. Así que el trabajo de entender de una manera bien detallada y bien informada de dónde estamos y cómo llegamos a este momento y qué es lo que se debe hacer de adelante, ese trabajo se ha hecho y se va a continuar haciendo.
Última pregunta, Noticel.
Hello. Has the board identified a deadline, a specific date as to the presentation of causes of action? You are running against the clock after all.
Board is going to be, subcommittee has just been formed. I think, David and I and Arthur, who had to go catch a plane, hence his not being with us. So I just wanted to take that opportunity to excuse him on that side. We don't speak for our colleagues. We understand, as the panel talked about, we're working under a pretty fast timeline. Cobra and Kim worked on a pretty fast timeline, and we'll be working with all deliberate speed to make the determinations that we need to make, and based on the findings that have been made. And I don't want to get ahead of our colleagues and give you a deadline that is not a realistic, but we understand where we're working. What we will have to work towards relative to the timeline that the court has put forward for next year, and we'll be working as quickly as we can to consider the recommendations in the report, the findings in the report, and other issues that have been raised, including by some of the panelists before us. Anything you'd add, David?
No, I would just reinforce that by saying the restructuring of Puerto Rico's debt is well underway. We've been in Title III for well over a year now, and this is all part of that process, and so we need to be doing it promptly, and we're aware of the need for acting expeditiously, not hastily, but expeditiously.
And just adding on that point, it's important to remember that many of the issues raised that will have to be further considered are issues that have been raised. Some are new,
Right.
But there are issues that have been raised and or issues that get raised in the context of resolving Title III. So it's some of these issues are already the subject of litigation.
Muchas gracias. Hasta luego.
Gracias. I'm a former prosecutor, so I don't prosecute cases anymore. But
Oh, he did say.
Have you seen anything so complex and so nobody's already ruled practically according to the.
That's a great question.
what I would say is that the people of Puerto Rico, it's a time for leadership, and this board has committed itself to that leadership. And it is a complicated fact pattern, and it was a privilege to work on. And we're very grateful to have had the opportunity to address in detail these questions in our report, and we direct you and the public to that report for our views.
So
Muchas gracias.
muchas gracias, buenas
Tenemos que
tardes.
retirarnos. Vamos. Ahora sí.